Hey everyone, a quick update video. The Mock V Garland case that is still slated to be heard together on August 5th with all the rest of the pistol brace regulations just got a decision from the district court judge. So we've gone up and down the ladder. And actually, if you go over to the Firearms Policy Coalition website, you have to kind of ride the ladder to get down to the district court to actually find the document that we're going to go over today. But the district court just vacated the decision. And what does that mean? Well, that and more after we hear a quick word from today's sponsor. Today's video is brought to you by XS Sites. I've been using their sites for years now. I gravitate towards their big dot sites, but they offer all kinds of profiles out there. Special thanks to XS Sites for making today's video possible. I'm going to skip down to the remedy because this is a 12-page document. We're going to go to page 11 where the actual meat and potatoes is. Finally, the court turns to what appropriate remedy is in this case. Plaintiffs request that the court vacate the final rule, which means throw it out, and grant permanent injunction, meaning that we're done here, and then if they want, they can appeal it up to the Fifth Circuit. In response, defendants argue that the court should not vacate the final rule as there are more limited remedies that could redress the plaintiff's injuries. Additionally, defendants claim that the court should deny requested injunction because plaintiffs have failed to carry their burden and requested injunction is too vague. The proper remedy for a finding that an agency failed to comply with the APA's procedural requirements is vacatur of the unlawful agency action. While defendants are correct that the APA does not require such a remedy, the Fifth Circuit considers vacatur the default rule for agency action otherwise found to be unlawful. Basically, what that says is the APA doesn't require, the Administrative Procedures Act doesn't require that if they violate the rules of this thing, that it has to be thrown out. It's just saying that the Fifth Circuit says, well, you're in our house now. And our way of doing business is if you do something illegal, we're just going to bust you all the way down to zero. It then goes on to define when it wouldn't do such a thing. But then it says, in this case, vacatur is appropriate given the court's conclusion that the defendant's adoption of the final rule violated the APA's procedural requirements. An illegitimate agency action is void and therefore cannot be remanded as there is nothing for the agency to justify. Further, applying the vacatur to the final rule to only the plaintiffs is more akin to the injunction that would prohibit defendants from enforcing its unlawful final rule against only certain individuals. And indeed, there are meaningful differences between an injunction, which is a drastic and extraordinary remedy, and a vacatur, which is a less drastic remedy. That is because the vacatur does nothing but reestablish the status quo that existed for decades prior to the final rule going into effect last year. Apart from the statutory basis on which the court invalidated an agency action, vacatur neither compels nor restrains further agency decision-making. Because defendants failed to show that this is a rare case in which the court should deviate from the default rule, the court vacates the final rule on grounds that the defendant violated the APA's procedural requirements in promulgating it. For these reasons said above, the court grants plaintiff's motion for summary judgment on grounds the final rule violated the APA's procedural requirements. Now, let's scroll back up because there's one thing that I wanted to bring to your guys' attention, because the FPC basically says that, hey, if this doesn't vacate the final rule, then we're going to be back here on Second Amendment grounds shortly. All right, Kurt. Well, I thought this thing died a while ago. No, it's ongoing, and it's going to keep on going. The next hearing for the combined cases is August 5th. And the reason I bring this to you is now that this is where it is, as part of the whole thing that's going to happen on the 5th of August, or the week of the 5th of August, these documents and the related decision can then be injected into the hearing that's going on the week of the 5th. So this is just another thing, another nail, if you will, in the coffin of the pistol brace regulation, the pistol brace ban that is ultimately going to end up at the Supreme Court. So everything that we cover related to this think of us just tacking more things onto the whole package that is going to end up at the Supreme Court eventually. And that's exactly what we want. Anyway, that's all I got for you guys. If you do the weekend thing, have a great weekend. And I don't know, I may even see you over the weekend. I don't know. Later on, VSO Gun Channel out.